Good evening. So we will get started here. This is the regular Board of Education meeting of Monday, November 4th. On the agenda tonight, number 2, is a presentation from Mark Sommaruga, who is representing the district and is here tonight at Grass. The board asked Mark to basically provide some information regarding status of the legal process that's underway regarding the Sommaruga High School renovation project vote. And we felt that given the situation and the fact that we have a couple of new board members since this vote was taken, that it would be a good educational opportunity to just review a little bit of how we got here, where we stand now, what the future may look like.
Just a couple things. First of all, if I sound too preachy or self-righteous, I apologize. That's not my intent to lecture anyone. This entire process, in terms of the lead up to the referendum, we know a lot of energy was spent by everyone. And let me just say, I think there are people of goodwill on both sides who, in terms of that vote that took place in June. No one doubts the people's positions on that. All I can say is the Board of Education, up to the election, there was a lengthy process, a building committee process. There was a lot of publicity about this, and it was a very controversial issue. Obviously, when the vote's 1,269, 1,265, so obviously, is a division that took place. Simply put, back in late June, it came to the board's attention that there was an issue that was raised about the question of whether there was proper notice for this referendum. And look, it's a serious concern. We take it seriously. The concern about the notice we give. Now, one of the things I've heard people say is the question about why don't we just have another referendum right now? We don't need, what do we do in court? There's a couple things that we need to keep in mind. When we had that referendum, it wasn't meant to be an advisory opinion. It was meant to be a binding vote by the electors of both towns, Bethlehem and Woodbury. And my concern would be every time there was ever a question raised, because, for example, 2 years ago, during the reconfiguration, there was an issue in the election about the ballot checking of ID in Bethlehem. And I would argue, frankly, this is what I argue in court, that is a much more serious violation than the legal notice that was put on page 62 of the Waterbury Republic, with all due respect to the towns who take a different position on that. We just can't, every time anyone raises a question, say, okay, fine, even though there was a majority of people voted on this, it was close, so we're just going to throw away the results. It was a tight election. It was a small majority, but it still was a majority. And for us to just say, okay, 1,269 people voted for this, we're going to, even though we have no power under law, just disregard your vote and have another election, that simply would not be right. I mean, the courts that deal with these issues, they've always said one thing when there's an elections violation. The remedy of having another election should be extremely, extremely, extremely rare. Because an election, is like a snapshot. What the voters wanted on June 18th of 2013. Every campaign has a certain dynamic. And the Supreme Court said it eloquently. If you have another election, it's not another election, it's a different election. And we should not be in a position of giving people a mulligan, to use an old golfing phrase, whenever there's a question raised. What the courts look to is, okay, in terms of the results, first of all, was there compliance with the laws, substantial or otherwise? And second of all, regardless if there was a compliance, is the vote still valid because there's been no prejudice shown? Again, for the 1,269 people, it would be unfair for those not to count their votes. However, we know there were 1,265 people voted against this. And, both sides have rights in this. The reason why we're here is simple. Make sure everyone has respect and legitimacy for the process. For example, for the 1,265 people voted against this, let's assume for argument's sake the judge agrees with us and says the election's valid. They may say, well, gee, you didn't follow the election laws to a T. Why are you going forward with the project? We could say at that point a judge has said that this is a valid election. And conversely, to the other side, if 1,269 people voted for this, they may raise, and this argument, and frankly, I've raised it in the courts, well, gee, this alleged violation, even if true, it was, you know, the fact that this was not adequately published on page 61 of the legal notice section, why should we declare a referendum that was otherwise valid, null and void? If a court says it must be null and void, we can tell the voters, hey, the court has said that this election should be declared null and void. It's not simply a technical violation, it's something important. So, what happened in this case, we tried to have this be as orderly as possible. There's not some grand conspiracy. I've seen some allegations that there's some conspiracy between the towns and the district of Cook something. The towns have taken a position, ironically, that they believe the election is invalid. It is interesting because according to the law, the requirements under law is that the town clerks are required to put the notice in the newspaper. I think everyone agrees on that it was the town clerk's responsibility. It wasn't done. I'm not here to, you know, point fingers, pass blame about it. It's a fact that it wasn't done. And the town's taking the position, at least the first selectmen have taken the position, they believe that the election should be declared invalid. We've taken a contrary position. We had a frank discussion over this. I mean, frank, was it cordial or not? I don't know. But it was with respect. And what happened is the town's position was, we have enough of a concern about this, we're going to bring a lawsuit. You know, now, is it a friendly lawsuit or whatnot? I'm not sure. But the key is it's not typical, we're going to court to seek monetary damages. You know, what the town was simply seeking, and we're joining, we have filed a counterclaim on this, is the question of, is this election valid? Was the notice valid? You know, if the notice was valid, was there enough publicity? Regardless of all these things, even if the notice wasn't valid, was the publicity enough so the election is valid? Simple question, either yay or nay. And to the town's credit, they kept it as simple as possible. The lawsuit in Litchfield has gone along the way I thought it would go along. They filed the lawsuit in mid to late July. In August, ironically, I know this is a lawsuit about notice for a referendum. There is a requirement under law that when you have a declaratory judgment action, that there's a notice put in the newspaper. We didn't want to have a situation where there was a lawsuit contesting the lawsuit over notice, so we thought we would comply with everything to a T. So what happened is the towns graciously, as part of this process, they had to post in the newspaper for a couple of weeks, or at least once every 2 weeks, notice of this lawsuit. That took place in August because the court gave an order in late mid-August. Next 2 weeks that was done. In September we got together and we tried to agree on a statement of facts. You know, this was a trial, but it was a very simple trial because the facts are not in dispute. I think we all agree what took place. You know, the newspapers speak for themselves. The articles speak for themselves. What was sent to the clerk speaks for themselves. There's no great mystery here. But we had to get together to put the facts together in a cogent manner so the court could look at it. We filed all this with the court. And then on October 9th, we had a trial. Those who were there, I think the trial lasted 1 hour. It was just oral argument. And also we filed briefs. To be very blunt, the case in Litchfield is done. I mean, we had the trial, filed the briefs. There's only one thing left for me to do in the case in Litchfield, is when the court puts in the mail the decision, I'm to look at it and read it. I think I owe it to you. I'll just read the decision. Besides that, the case is done. Everything's done in Litchfield. Nothing more to do. And I thought that there was a process that would work for everybody.